I rise to speak on behalf of the Coalition in relation to the Constitution Amendment Executive Council Bill. This is a bill which seeks to amend the New South Wales Constitution and would extend the extraordinary provisions introduced during those extraordinary times, which were the COVID pandemic, into ordinary times. This is the second time in the life of this Parliament on which this government has sought to amend the Constitution, and it behoves us to look very carefully at any changes to this important document, which provides the authority for lawmaking in this state. By Section 5 of the New South Wales Constitution, power is conferred on the legislature to make laws for the peace, welfare and good government of New South Wales in all cases whatsoever. And in Section 3, subsection 1, legislature is defined as meaning His Majesty the King with the advice and consent of the Legislative Council and Legislative Assembly. The Australia Acts at Section 7, subsection 1, make it clear that this power of the King is to be exercised at all times by the Governor of New South Wales, unless the King should happen to be personally present in New South Wales. And Section 35, capital B of the New South Wales Constitution provides that the function of the Executive Council is to provide that advice to the Governor in respect of the government of the state contemplated by Section 5, and which is a necessary part of the doctrine of responsible government, which is expressly preserved as part of our constitutional arrangements by Section 35, capital A. So the Executive Council is not some mere historical artefact left over from a bygone age. It is an integral part of our system of government. It is a constituent element of our tripart legislative process, and the provisions of the Constitution referring to it should only be altered with care. Which is why, while we recognise that extraordinary times call for extraordinary measures, in ordinary times, there needs to be a compelling case for change to the operation of the Executive Council. And that case has not been made by the proponents of the bill. As the Honourable John Graham said in his second reading speech, the extraordinary times of COVID required an amendment to the Constitution in order to allow individuals who were required to be present at Executive Council meetings to be present by way of teleconference or video conference. These were temporary measures introduced in response to a temporary problem. However, it is foreseeable that circumstances will arise again which will require flexibility, ensuring continuity of executive government and executive council meetings. In that sense, it is sensible to introduce this amendment, which enables meetings to be held remotely where necessary. I would emphasise my last two words, where necessary. It is not clear that this bill is addressing any current issue other than possibly the convenience of ministers. In its current form, the bill provides for remote meetings of the Executive Council at any time and for any reason. It is not limited to extraordinary circumstances. The Coalition believes that this represents a risk that future ministers, certainly not any member of this place, would be able to quite literally phone in one of the most important duties and one of the most important stages of the carriage of legislation in New South Wales. The cooperation of the Governor with Cabinet is an essential part of our very successful democracy, and one which we should not tamper without clear and demonstrated need. So I foreshadow that I will be moving an amendment to this bill which provides the flexibility that the government seeks for the continuity of executive government, but only empowers Executive Council meetings to be held remotely in exceptional circumstances. It would make the Constitution consistent with the arguments which have been made for this change. As such, it responds well to the needs arising from a situation such as a COVID pandemic, while at the same time recognising the importance, the continuing importance of the Executive Council and safeguarding against those hypothetical ministers seeking to phone in one of their most important duties.